The matter commenced slightly after 9 a.m. as the court had a short course list to deal with before embarking on this particular matter. When the matter was called out, there was a little shift as the matter was preceded by an oral application by the defense. It took the form of a complaint against the police. Mr. Ondieki almost got emotionally carried in explaining the difficulty he had in accessing the court. He complained that he was prevented from accessing the court. The same position was replicated by Mr. Njiru. Upon hearing the prosecution response, he attempted to get a workable and practical approach to the issue. I tasked the court administrator to provide a screen outside the court premise so as to enable the members of the public who could not be accommodated in the courtroom to follow the proceedings from therein, which direction was complied with. The matter to me appeared resolved. When we resumed the sitting at about 10:30, Mr. Ndubi, learned counsel for the accused person, narrated his difficulty in accessing the court premises. He alleged to have been blocked by the police officers. For clarity, on the latter assumption, 4 accused persons who were earlier present were absent. Mr. Ndubi, in explaining this, stated that 4 accused persons were prevented from walking into the court after a short break. He extensively submitted, alluding that their absence had been occasioned by the police. He submitted that based on the circumstances, it is not possible for the matter to proceed and that it is not possible to conduct a fair trial under the circumstances. He asked that the matter be adjourned indefinitely until such time that the members of the public are allowed to follow the proceedings. He even suggested that the venue of the trial be changed to a more spacious trial, with strong suggestion to have the hearing conducted at Accra Stadium. He submitted that the police action, which he described as militant, should not be permitted under the new dispensation. He promised that he would not participate in the proceedings should the court direct that the matter proceeds. He rested his submission at that. Mr. Ondieki had this to say. He confirmed participating in the formulation of a compromise direction respecting the participation of the members of the public through following the proceedings from the screen to be mounted outside the court. He, however, with visible anger, submitted that as they were implementing the direction, the following persons were arrested: Julius Kamena, Jackson Masharia, James Mwangi, and James Maina Mwangi, who is a clerk in his law firm. He submitted that the 4 accused persons were similarly prevented from accessing the court after the break. He submitted that the police actions are not only unconstitutional, but are also actions of impunity. He submitted that the police action is making it impossible for the trial to proceed. Mr. Njiru, on his part, commenced his submissions by stating that given the level of what he perceived to be intimidation, no officer should be permitted inside the court premise while armed. He submitted in furtherance that the 4 accused persons who are not present in court have been prevented from attending court by the police. From accessing court by the police. He asked that the court, under the circumstances, should exercise its authority to ensure seamless flow of proceedings. He called for the summoning of the police commandant to first explain the whereabouts of the 4 accused persons not in court. Secondly, explain why the roads have been barricaded, leading to harassing of members of the public. And finally, explain to court how important this case is against other cases to warrant such level of impunity. Mr. Cheche, on his part, admitted that it is not possible to proceed with the hearing in the absence of the other accused persons. His view was that the police action is a clear sign of panic based on the hopeless case they are pursuing. Mr. Mungiki, on his part, refuted the claims by the defense. Mr. Mwenga's view was that the defense, by conduct, are persistent on having the matter adjourned. His view is that the 4 accused persons who were present earlier had voluntarily absented themselves. Hence, he applied for warrants against them and called for the forfeiture of the cash bail deposited by them. The defense reiterated their application on bail. This is the court's considered here. This is where I choose to begin. First, this matter is properly before me. This court is by law says of the requisite jurisdiction to hear and determine this matter. As a reminder, I derive my authority from Article 159 of the Constitution. I find it, for purposes of emphasis, to restate. This is Article 159.1. Judicial authority is derived from the people and vests in and shall be exercised by the courts and tribunals established by or under this Constitution. In exercising judicial authority, the courts and tribunal shall be guided by the following principles. A. Justice shall be done to all irrespective of status. B. Justice shall not be delayed. I move to E. The purpose and principles of this Constitution shall be protected and promoted. Under Article 161, in exercise of judicial authority, the judiciary, as constituted by Article 161, shall be subject only to this Constitution and the law, and shall not be subject to control or direction of any person or authority. The above provisions are in simple language and they are unambiguous. It is against this backdrop that I operate. It is worth stating that these are judicial proceedings whose authority is as above read. In execution of this mandate, and with strong bias to criminal proceedings as in the instant case, the judiciary plays a pivotal role in the justice process. It though does not act in isolation, it corroborates with other agencies, but with strong need of preserving its independence. In relation to this case, I must state that the volume of rulings that have been done in the instant case constitutes more than 10 times the volume of the substantive proceedings respecting the substantive case. I must state that I am interested in the charge sheet and indeed taken the proceedings of PW1. Regrettably, I find nothing unusual about this case. It has been unnecessarily hyped. There is clearly nothing peculiar in this case to deserve the attention it is receiving. It is receiving, clearly, there is clearly nothing peculiar in this case to deserve the attention it is receiving. It is not now, but since its inception. The manner of proceeding adopted in the instant case is a public hearing. This mode permits the presence of members of the public at the trial. This is in consonance with the accused's right to public trial before court as enshrined under Article 52D of the Constitution. A threat to that right has been alluded to by the defense. The defense alluded to the fact that members of the public have been denied access to court to follow the proceedings of their interest. The interests, though, have not been defined or described. That right cannot be extinguished by non-definition of the interest. The learned prosecutor maintained that no member of the public has been denied access to court. He, though, on the contrary, indicated that he has had to identify himself so as to be allowed to the court. The complaint as fair is against the police, who are accused of first preventing public access to court, and secondly, harassing members of the public, including persons coming to court for other services. This complaint is intertwined with the defense assertion that the four accused persons, namely Daudi Mwangi Chege, Simon Mungai Mato, John Kuria Karipu, and Peterson Wanjao Ndirangu, have been denied access to court. Were the assertion to be true as alluded, and that the police are responsible for denying the said access, then I would describe it as unfortunate and clearly unacceptable and not tenable at all. It is a clear mode of impediment to justice and act impeding the court exercising its function. That assertion, though presented as submission from the bar, deserve further interrogation. The police role, other than in the trial, is to provide security and ensure maintenance of law and order. Where there is such attempt of breach of peace or order, then the police shall be called to action. Nothing of the sort has been exhibited in this case. Preventing an accused person from attending to the place of trial is a confrontation first of the accused right to the trial, and secondly, impediment to execution of the function of the judiciary. This court has a duty to issue administrative direction to ensure seamless flow of trial. In the end, I give the following direction pursuant to the application. 1. The matter shall proceed in a public manner, and members of the public shall be permitted to follow the trial to the extent of such number that this courtroom shall accommodate. 2. Considering the interest the case is attracting, though not defined, this court's administrator shall make available an extra space within the court's compound where she shall cause to be mounted a screen to enable for persons who shall so, based on the available space, be accommodated to follow the proceedings from therein. 3. That it shall be the duty of the police, specifically the OCS Nakuru Central Police Station, in direct liaison with the court administrator to ensure orderliness within the courtroom and the extra space be provided. 4. The police shall, under the direction of the OCS, Nakuru Central Police Station, ensure that there is ease and ensure that there is ease access to court by members of the public. 5. No accused person shall be denied access to court for whatever cause or reason. Finally, this matter is adjourned to tomorrow, the 22nd of November 2023 at 9 a.m., where we shall proceed with the hearing. Those are the orders of this.